Well, the case office agreed that this defines a novel sequence in a new method. However, the patent office said that this doesn't define patentable subject matter. Why? Because it uses an algorithm which programs a general purpose digital computer. They didn't like that, and so the case went all the way up to the Supreme Court. It was decided by Justice Rehnquist, now Chief Justice Rehnquist. And he rendered a decision in favor of the inventors, a slim majority. He held that the claim is drawn to statutory subject matter. Now, it's rather interesting that in his opinion, he talked a little bit about the history of the patent system, and then he gave some examples of things that are not patentable. Recall that in the copyright statute, we saw that there was an itemization of things that were not copyrightable. The patent statute doesn't have that, but we have to go to the case law. And he enumerated a few things that we know do not fall into the category of patentable subject matter. You can call this like the patent equivalent of the binary zero category. A new mineral that is discovered in the earth. A new plant found in the wild. And then he talked about some principles like Einstein's law, E equals mc squared, the law of gravity, F equals ma. Or if someone proved mathematically that the most efficient way to stack oranges is in a pyramid. It could be a mathematical proof. That does not define patentable subject matter. On the other hand, he did refer to a statement in the House and Senate committee reports that was just prior to the 1952 statute. The statement stated that the Congress intended that patentable subject matter include anything under the sun that is made by man. If you notice, they wrote in the masculine gender. The boys weren't so PC. Give them a break. Anyway, though, Justice Rehnquist then went on to, on behalf of that 5-4 majority, that this does define patentable subject matter. He said that the mere fact that the inventor is using a formula, an algorithm, or a general purpose digital computer should not detract from the patentability of the invention. And he then went on to state simply that a claim drawn to subject matter that is otherwise statutory does not become non-statutory simply because it uses a purpose digital computer. What does he mean by otherwise statutory? What he means is that it has to meet the creative part of the statute. It has to be novel and non-obvious. And the other part is it has to fall within a category of subject matter that is one of those that patents cover. So after that decision came down, the proponents of software based in patent protection said, well, our ship is coming in, things are getting better for us, we're going to get protection. It looks like we're probably going to get some patent protection after all. Those who were against patent protection for software-based inventions said that this is only limited to patent protection if it's a software-based invention that produces something physical or tangible, like in this case, molded rubber. So, you know, some of you might say, doesn't that seem like a silly distinction? Well, people who are on one side were making every argument that they could to support their position. Others on another side were making every argument that they could to support their position. So it was only a matter of time before the courts would have to eventually deal with software-based inventions where the output product was not something physical or tangible, which actually occurred in the State Street Bank versus Signature Financial. Now, there is something that is of interest that occurred. In the decision of Diamond versus Deere came down around 1981. In 1982, the Congress enacted legislation to form the Court of Appeal for the Federal Circuit. That means that Court of Appeals had exclusive appellate jurisdiction of all patent infringement cases. Some people, patent owners, thought they weren't getting a fair shake from the regional courts of appeals. You remember we talked about the First Circuit, the Second Circuit, the Ninth Circuit. Some of them were rendering decisions that were anti-patent. So they lobbied the Congress. They got the Court of Appeals for the Federal Circuit formed. And so all patent appeals went to one court. And there was a marked change in the attitude of the judiciary toward patents. They didn't invalidate patents as often as they did. They didn't seem to be quite so hostile as they were in the past. I've heard speeches by members of the Court of Appeals. They say that they're not very pro-plaintiff, they're not pro-defendant, they're just in favor of the statute, and they just interpret it the way it is. It was always that way, but whoever interpreted it the other way before us was wrong. But anyway, though, the patents seem to be had a greater success rate after 1982. Okay, I'm getting vibes from the control booth. I think we got to take a break. So how long are we going to adjourn for? A few minutes. Okay. Before we take a break, let me make an announcement. Do not talk to each other about the case until all the evidence is in. Do not talk to the press. We're going to adjourn for about a few minutes, and then we can. Okay, let's reconvene. In 1998, the courts began to address the issue of software-based inventions, which had to do with an output which was data as opposed to an output which was just something physical, like the physical structure of a molded rubber. And this was the case of State Street Bank versus Signature Financial. That also came out of Boston. Seems to be that, well, there's a lot of interesting litigation that comes out of Boston. Federal court here had the case, and it involved a patent which was used to produce information for a mutual fund. And the defendant, that is the accused infringer, contended that it was not liable for infringement because the patent was a software-based invention that produced data as opposed to something structural, like, for example, the molded rubber. Well, actually, the trial court held in favor of the accused infringer, in this case, State Street Bank, and the appeals for the Federal Circuit said the mere fact that it's a software-based invention that produces numbers such as price, profit, percentage should not detract from the patentability of the invention, so that if it's a software-based invention and the output is just information like that, price, profit, something intangible as opposed to tangible molded rubber, that defines patentable subject matter. There's another interesting aspect of that case, and that was the method of doing business to inventions. There was a case that was decided at the beginning of the century. It was a case for which people relied on the proposition that you can never get a patent on a method of doing business, and people interpreted it that way. And the Court of Appeals for the Federal Circuit re-examined all of this, and they said, no, that's not what the case said. You can obtain a patent on a method of doing business. You can obtain a patent on a method of doing business where the output is such as mutual fund data.